So
Yeah. Uh, and we are live. Thanks everyone for coming in, and we'll get started momentarily. I'm here with Leah Litman, a professor of law at University of Michigan and the author of Lawless, that book you can see right behind her. And we are talking today about the Supreme Court decision upholding Tennessee's ban restricting gender affirming care for some minors, namely transgender minors. And we're going to get into that in a second. But before we begin, I just wanted to start things off by talking about the fact I was actually in Tennessee very recently for the case of Kilmar Abrego Garcia. And the day after that hearing, that detention hearing, went to the No Kings protest, spoke to a few people there. One of the people I spoke to was Ray, and Ray is transgender. I was asking folks there, why did they go to the protest? What brought you there? And Ray told me about the life or death stakes of this issue for the transgender community, and that restrictions on medical care, in particular, has life and death stakes. And days later, here we are with this divided 6-3 decision from the Supreme Court spanning more than 100 pages. I encourage viewers to read the ruling. To really, there's just so much in there. We're going to hit the key points here, but it goes to those life or death stakes. And before we go to the questions, I'm just going to read this passage from Justice Sotomayor's dissent that speaks to the problem of suicide in this community and related to care. Suicide in particular is a major concern for parents of transgender teenagers, as the lifetime prevalence of suicide attempts among transgender individuals may be as high as 40%. Tragically, studies suggest that as many as one-third of transgender high school students attempt suicide in any given year. So, setting up those stakes here, and Professor Litman, if you can just walk us through the crux of the majority opinion here. Want to get to the stakes before the legalese, but the legalese is important because it goes to the breadth of this issue. The court found, as I understand it, that the 14th Amendment's heightened scrutiny did not apply under the Equal Protection Clause. And the ban, they found, the conservative majority found, survived rational basis review. Now, unpack all that for those who are tuning in.
absolutely. So the Equal Protection Clause of the 14th Amendment prohibits states from denying people equal protection of the laws. And what the Supreme Court has said is when states draw distinctions on the basis of certain characteristics, those laws with those distinctions will trigger heightened scrutiny. If they contain distinctions that are called suspect classifications, where historically those distinctions have resulted in a lot of discrimination. So, for example, distinctions based on race or distinctions based on sex. Those are suspect classifications that trigger heightened scrutiny. So the Supreme Court addressed two different arguments for why this law might have contained suspect classifications triggering heightened scrutiny. One was the argument that the law contained a distinction on the basis of sex, that it discriminated on the basis of sex. The law, after all, mentions sex 19 times and restricts medical care and prohibits its availability based on whether an individual is trying to not live in accordance with their sex assigned at birth. So that looks, sounds, talks, walks like a sex distinction. But what the Chief Justice's majority opinion said is it's not a sex distinction because it treats trans youth who are boys the same as trans youth who are girls. So that's not a sex distinction. Also, it's in the medical context and there are special rules there and it concerns a medical procedure. And also, this is about age. So that was the analysis on why it wasn't a sex classification. The court next addressed the argument that it was a distinction based on gender identity. So a form of discrimination against the transgender community and transgender individuals. There, too, the Republican supermajority said this law does not draw a distinction on the basis of gender identity. And I think here the reasoning was in some ways even more specious because the law prohibits the availability of certain medical treatment, hormones, and puberty blockers only when they are used to treat gender dysphoria. And of course, gender dysphoria is where an individual's gender identity doesn't correspond with their sex assigned at birth, which is pretty bound up with gender identity and being transgender. And so the Supreme Court said, sure, the group that's negatively affected by this law is only trans people. But guess what? Both cis and trans youth can still access hormones and puberty blockers to treat other conditions aside from gender dysphoria. Therefore, it's not a distinction on the basis of gender identity. So that's the brief synopsis of the majority opinion.
Right. So I want to go into one of the things that you touched upon here, and this is at the heart of Justice Sotomayor's dissent, where the one of the things that she pointed out, I've seen some headlines that the Supreme Court upheld a ban on gender affirming care for children. And that's not entirely true. If you look at Justice Sotomayor's dissent, it's a ban on gender affirming care for transgender children. She points out that if your child has a hirsutism, which is male hair growth, if you have a daughter with male hair growth and does not want that male hair growth, you can get treatment for that, including, as you mentioned, puberty blockers and hormone therapy. If your
Yep.
child has early onset puberty, what's known as precocious puberty, you can get the same medications. But if you replace precocious puberty or hirsutism with gender dysphoria, then the ban takes hold. Can you talk about that and how the heart of the dissent and why that goes to the Equal Protection Clause?
Yes. So I think in some ways the majority managed to twist that into a reason why the law did not discriminate against trans people, even though, in my view, and according to the dissent, I think correctly, that's just an obvious sign that the law does discriminate on the basis of gender identity and against trans people, because the kinds of treatment it separates out, the kinds of treatment it prevents, is the kind of medical care that transgender individuals seek to live in accordance with their gender identity. To get puberty blockers so that they do not develop develop sex organs and whatnot, that are not in accordance with their gender identity, or hormones that would allow them to live in accordance with their gender identity. And so by prohibiting the use of this medicine only to treat conditions that are so inextricably bound up with what it means to be transgender, with transgender status, you would think that's a pretty clear sign that the law does indeed contain a distinction on the basis of gender identity and discriminate against trans people. And yet the Chief Justice somehow turned that reasoning on its head and said, well, no, no, no. The fact that both trans and cis kids can access the medicine for different reasons means it's not discrimination. It's just topsy-turvey logic, I think, and reveals the extent to which this court is so insistent that there is no discrimination against the LGBT community. It will just engage in this convoluted, tortured logic to explain why LGBT discrimination isn't actually discrimination. I write about that a lot in the book.
So, just to put a fine point on it, if one's daughter or son wants gender affirming care for a reason that to affirm the gender assigned at their birth, that is fine under the Tennessee law. If your son or daughter wants gender affirming care for a gender not assigned at birth, that is what the law restricts.
Exactly. And again, that is just defining what it means to be cisgender and transgender. It's such a clear distinction on the basis of gender identity.
Right. And so one of the reasons that I ask that, if you look at the majority opinion, one of the things that they talk about is the issues about informed consent and drug safety. So let's unpack that a little bit. These are the same treatments, the same medications that we're talking about here. Puberty blockers, hormone therapies. The authorized use of these drugs under this law and now affirmed by the Supreme Court, they can still be used. The same drugs, same effects under the care of a physician. Do I have any of that wrong?
No, and again, it's just astonishing because it underscored the extent to which it felt like the Republican justices were setting up this straw man. And it also undermines the state's justifications for the law because the state says, oh, we are concerned about the effects of this treatment. But you're totally fine with the effects of administering the exact same medication just to treat other conditions. There's a reason why the Food and Drug Administration doesn't prohibit doctors from prescribing medication for what's called off-label use. That is, once a drug is approved, it can be prescribed for reasons other than what it's primarily used for, because once the drug is safe, it's safe. And yet Tennessee and the Supreme Court are suggesting these hormones and puberty blockers, which again can be used, right, to treat some conditions, all of a sudden become horribly unsafe. And all of a sudden we're worried about informed consent and parental consent when they're used just for these one set of purposes. It's
And the
very
same
silly.
medications,
Yes,
same
same
medications.
medication.
So, in one of the language, correct me if I'm wrong, the language of the Tennessee law at issue says that the purpose of the law is for the children, the minors, to, quote, appreciate the gender of their birth. Correct?
Yes. I mean, that's just one of the mentions of gender and sex in this law, and why it was very strange to see a court that has adopted what's called the anti-classification principle insist that this isn't sex discrimination. Because according to this anti-classification principle, the only thing that matters is whether a law draws a distinction on the basis of sex or race. It doesn't matter why it did so. That is, it doesn't matter if it draws a distinction on the basis of race to create a more inclusive community. It doesn't matter whether it's drawing a distinction on the basis of sex for affirming biological differences. A distinction on the basis of sex is a distinction on the basis of sex.
hmm And it's you often hear folks say who fall on the majority side of this opinion. They talk about other countries that have adopted similar restrictions. One of the things that the dissent notes these countries. I believe Denmark is one of them. The Netherlands is another. These countries do not have across the board bans.
Yeah,
If someone has gender dysphoria and that it is a life-threatening condition. In these
exactly.
countries, that is not what takes place, correct? So,
Yes, exactly. They regulate it, right? And they limit the circumstances in which it is available, but it remains available for these serious cases of gender dysphoria, where the lack of the availability of the treatment really threatens an individual's life, health, and safety.
right. I just want to take a moment to read one part of the dissent for folks watching, just to we've been focusing on the legal issues and they're important. I'm going to return to that in a second. But just to say a little bit about the plaintiffs as revealed in the dissent. Ryan Rowe, now 16, felt as early as elementary school that he was a boy. Before puberty, Ryan thought there wasn't that much of a difference between boys and girls and that he could manage existing in the middle. As puberty approached, however, Ryan grew increasingly anxious about the impending changes to his body. He started throwing up every morning before school. As his voice changed, Ryan contemplated going mute. Eventually, after 2 years of psychotherapy and extensive consultation with his parents and doctors, Ryan's physicians prescribed him testosterone. Ryan began to find his voice again. He started raising his hand in class, participating in schools, and looking at himself in the mirror. Ryan attests that gender affirming healthcare saved his life. So I just wanted to throw that in, just so the perspective of the parents here. This is in the court record. It is simply not an option to cut him off from this care. I worry about his ability to survive, Ryan's mother attests. Losing him would break me. That is from the Supreme Court dissent by Justice Sotomayor and joined by the other justices. I want to go back to the legal findings because they're important beyond this case. Uh, walk me through the ramifications of the court finding that that transgender children in this instance are not a quasi suspect group under the Equal Protection Act
Yes.
clause, excuse me.
Yes. So two things. One is, and I think most clearly, obviously, this allows not only Tennessee, but states with laws like Tennessee to enforce these bans on gender affirming care for transgender minors. And that's going to create this patchwork of conditions where healthcare just is not available to some individuals and some families in the United States. That's going to create, again, the landscape that resulted after Dobbs, where, women in some states, pregnant people in some states could access abortion care and some individuals could not. So that's kind of the most immediate effect. And then I think the longer term implications are less clear because it depends a little bit on what the Supreme Court says on this unresolved legal issue that some of the Republican appointees weighed in on, and also how the court understands the second part of its opinion. Because if the court understands the second part of its opinion, which said bans on gender affirming care for trans kids, that doesn't discriminate on the basis of gender identity, that would conceivably allow states and the federal government to ban gender affirming care, not just for minors, but also for trans adults. And that is terrifying. Um,
Mm,
and then there's this lurking issue about in the event you actually had a law that explicitly discriminated against trans people as such. So imagine a federal law that said doctors don't have to provide health care to trans individuals, or places of employment don't have to hire transgender individuals. Would the Supreme Court subject that explicit, targeted, invidious discrimination against transgender individuals to heightened scrutiny? We don't know. Three Republican appointees, Justices Thomas Alito and Barrett, said they would not. They would treat those laws as also presumptively constitutional. The Chief,
mhm.
Kavanaugh, and Gorsuch did not say one way or another.
Right. And just for folks watching, the opinion itself, it's more than 100 pages and a patchwork of concurring opinions, dissents, and some of them revealed the way the justices were thinking, including, as Professor Lippman just said, Amy Coney Barrett. Um, what struck you about those concurrences and what they could mean? You started going into that. But where future battles for transgender rights may be going as revealed by these concurring opinions.
I mean, there's definitely going to be a fight about whether laws that single out transgender individuals, do trigger heightened scrutiny, because I worry that this opinion is going to embolden states to adopt more targeted discrimination at the trans community. And the separate concurring opinions by Justices Thomas Alito and Barrett were just gratuitous in my mind. You didn't have to resolve this question in order to uphold the law. Why weigh in to say we would allow states to go after the trans community in even more potentially harmful, targeted ways? It just felt extremely callous and non judicious, again, because it wasn't necessary to resolve the case. And then third, I just think there's incredible hypocrisy shown in those opinions. I mean, you have Justices Thomas and Alito pointing to what other countries are doing. Those are the same justices who used to castigate their colleagues for looking to foreign law when resolving Eighth Amendment issues, but I guess foreign law is good now. You
Mhm,
also
mhm,
have Justice Thomas criticizing the self-proclaimed experts on gender dysphoria before he launches into this long, lengthy exegesis of his own views about gender
mhm.
dysphoria. Who made you an expert? So they were really disappointing, I think, to read on top of the disappointing results in the case.
Mm. What you said is absolutely true. Folks who read Justice Thomas's concurring opinion, it's just this long Jeremiad about medical orthodoxies sometimes being proven wrong, and very interesting in light of his own history, as you said over there. So, in terms of just again, want to read one more passage again from the dissent about LW, one of the plaintiffs. Began to question her gender as early as fourth grade. At the time, she felt like she was drowning and trapped in the wrong body, often sick at school because she did not feel comfortable using the boys' bathroom. At age 13, LW and her parents sought out medical treatment. Puberty blockers and estrogen prescribed to LW after consultation with her parents and doctors changed her life. So this is the dissent, um, really just showing the stakes of this, of the real people involved, and one of whom reacted to the decision in that New York Times editorial that I encourage folks to read. Are there any thoughts about what's next for for transgender rights after this opinion? And folks who are watching now, who might want to support the transgender community in Tennessee and elsewhere.
Yeah, so I would say three things. One is that nothing in this opinion prevents state courts from striking down bans on gender affirming care for transgender individuals on the basis of state constitutions. Nothing in this opinion prevents state legislatures from repealing bans that target transgender health care. Nothing in this opinion forces state legislatures to enact these bans. So it still remains important to organize on the state and local level to try to protect this community. Second is, and I want to credit Chase Strangio, who is the director of the Transgender Justice Project at the ACLU and who argued the case on behalf of the parents of the trans minors. As he pointed out, it's clear that the majority's opinion draws from the cultural milieu and context in which it is immersed, which has become rife with this anti trans narratives. We all have a role to play in fighting back against those harmful narratives and recognizing transgender rights for the civil rights that they are and transgender individuals for the people that they are. And then the third thing is, I would say, it is important to recognize, I think that the court's opinion threatens more than trans lives in the trans community, which is already devastating. And I'm so glad you read the excerpts from the opinion that underscore that. But the court's logic, I think, threatens legal protections against sex discrimination, threatens to roll back other civil rights revolutions as well. So we are all in this together, and we should all invest in trying to create those legal protections in fora and in political sites where we can.
Thank you, Leah. And to your point over there, it one of the things that Justice Sotomayor said in her dissent is that at the heart of this sex stereotypes. What men it should, the idea of what gender affirmation would mean for men and what gender affirmation would mean for women. In Tennessee, this ban determines whether or not you'll get medical care depending on the purpose of that gender affirmation. So, just to underline your point about how it goes to gender and sex more broadly than this opinion, which is why I think it's so important to really dive deep into the weeds about the facts and law of this case and understand why it's not a ban on gender affirming care for minors. It's a ban on gender affirming care for some minors, namely transgender minors. Do you have any closing thoughts and about anything on this topic or anything else?
I would say, to the extent you can, try to support an organization that is trying to give support to the LGBT community, in particular LGBT youth at this time, like the Trevor Project. The Trump administration unfortunately withdrew their support that allows individuals to press a button to obtain counseling from the Trevor Project, from an expert in LGBT mental health. If they call the National Help Hotline, you can still call the Trevor Project in particular, but I think they need the resources to get that message out so individuals know where to call. So that's one thing that I would encourage people to do.
Mm. And it's a double whammy. What you pointed out, there's this Supreme Court opinion upholding this ban, but there's also the Trump administration's action. The thing that you're talking about right now goes to transgender youth at risk of suicide, and the funding has gotten cut. And the Supreme Court has authorized an action that the expert evidence submitted to the court shows will
Yeah.
put more children at risk of suicide. So it's two things in 1 week,
Yeah.
in a devastating week for the trans community.
And
Thank
then
you.
one other thing.
Oh, keep going.
So just to underscore the deep hypocrisy of this opinion, here the court literally said a ban on medical treatment for gender dysphoria is not discrimination against the trans community. We are waiting for an opinion where the Supreme Court is poised to say merely reading storybooks to children that contain LGBT characters, that unfairly burdens and discriminates against the religious beliefs of parents who object to LGBT equality. So, this double standard about what constitutes discrimination and who is discriminated against, I think belies the real
Mm.
ideology that is at work at the Supreme Court right now.
Right. And every time you mention another point, it's so incisive and makes me remember another thing from this dissent. Justice Sotomayor had mentioned, imagine, take away the kind of context of trans kids. Imagine there was a law that said something along the lines of a Jewish kid uh, can't partake in any ceremony inconsistent with the religion assigned at birth. And that's the same application being paid here to medical care. If you want,
Yeah.
if you're a parent who's thinking about what medical care your child is going to have, as long as it's consistent with the gender assigned at birth, no problem. Same medicine under Tennessee law. Thank you so much, Leah.
Thank you.
If you want, Leah is also the host of the podcast Strict Scrutiny, which is one step above the heightened scrutiny, which that this opinion discusses, all under the same concept. I encourage you to listen to her podcast. If you tuned in late and you want to hear this full discussion along with some other thoughts, subscribe now to All Rise News. It's on the top left of your screen. And we'll have other conversations like these to help make sense of Supreme Court opinions and everything like that. Thank you very much, Leah, and looking forward to chatting again sometime.
Sounds great. Thanks for doing this.
Thank you. Bye bye.